So, hello and good morning, everyone. My name is Annabelle Brett, and I just want to say a few words of welcome and of thanks before I hand over to Matti Koskiniemi for his introduction. So first, a very warm welcome, both to this conference and to Cambridge, for those of you who've come from outside. We're delighted that so many of you were able to be here, and we look forward to what I hope will be a really exciting and stimulating intellectual event over the next couple of days. Secondly, I want to say some words of thanks to our sponsors who have made this possible. In the first place, I want to thank the Cambridge Centre for Political Thought, which is providing half the funding for this. Political thought takes place in various places in the University of Cambridge. Within history, there's the Political Thought and Intellectual History subject group, but there are also people interested within the American subject group, within world history, within modern European. And then there is the Department of Politics and International Studies, which is, as its name suggests, is both politics and international studies. So the Cambridge Centre for Political Thought is really a forum in which people working in different institutional locations can come together and share ideas. And we're delighted to be able to extend that network to law and international law as well by means of this conference. Behind the Cambridge Centre for Political Thought stands the Cambridge University Press, which again they are very generous in funding. In Cambridge there's a long-standing association between political thought and the press. They have always been enthusiastic sponsors and supporters, as well as publishers of work going on in political thought in Cambridge. So we're very pleased to acknowledge them here, and we're delighted to have Fionnuala O'Sullivan from the press here today, from law, and then Liz Friend-Smith from political thought will be here tomorrow. Three other institutions have generously sponsored us. The first is the Eric Castrain Institute for Human Rights in Helsinki, of which Matti is the director. The second, the History Faculty of Cambridge, the Trevelyan Fund, who've helped us, and also the Lauterbach Centre for International Law, who've all contributed to making this possible. So very many thanks to them and to their representatives that are here today. That's all I want to say, and I hand over to Matti now for a more intellectual introduction. Thank you.
What a pleasure it is to stand here now. 2 years ago, Annabelle and I, at a conference in Utah, in which some of you were present, were thinking about, well, shouldn't we finally have a more organized frame for the debates that we had been having between historians of political thought and international lawyers in the past years, not knowing that in those 2 years, whilst this has been organized, that the number of those debates had increased tremendously, something that's really witnessed by the fact of how many we are here. There would have been many more had we had a stadium reserved for this purpose. I'm sure we could have filled it. So that's wonderful. We've been, as lawyers, reading with great interest, learning from historians of political thought. And I hope that historians too have been reading legal stuff and learned something about the vicissitudes and oddities of law in the international frame. But we've also often been puzzled and surprised about what our interlocutors on the other side of the fence have been suggesting and how they lead their lives on those other sides. One thing that always struck me as a lawyer when I met with historians and I heard them speak with each other and I spoke to them was that they always wanted to be clear which period they were working in. And it was only after they had specified that fact that they could have a respectable stand from which to make their propositions. So the period is the historian's standpoint. Of course, when then you speak to lawyers, then you hear things such as I'm working on private law, I'm working on property, I'm working on the Constitution, or maybe on legal institutions. Norms, laws, very different from periods, of course situated inside each other in complex ways. And I suppose it's those complex ways in which periods and norms interact that has created the interest in our mutual conversations. History and law are, of course, frames of understanding, also frames of engagement. As frames of understanding, I suggested already, historians think in terms of periods. It's important to know about the Italian Renaissance. It's important to situate something in the French Enlightenment or maybe in the interwar. Whereas for lawyers, the frame of understanding is, well, are you a private lawyer or a public lawyer? And if you're a private lawyer, is it family law or contract? And in public law, are you a constitutionalist or an international lawyer? Again, so the frames, these vocabularies open very different worlds, and it's anything but obvious on how those worlds relate to each other. So these are frames of understanding. There is a way of, or actually two ways, of making dreadful mistakes. If you're a historian or a lawyer and entering the other's territory. One mistake for a lawyer would be to think in terms of reducing those various periods to the laws of constitutions, to arrangements of family or of contract. Surely there's something specific that those periods give to us. What might that be? On the other side, I suppose the opposite problem would be a reduction of the norms to the periods. And of course, these two problems or two dangers, reduction of understanding to either just norms or just periods, these problems are what bring us together. It's not obvious how periods and norms link to each other. I said that the law and history are also frames of engagement. The way we speak about our periods and our norms is largely dependent on the audience expectations to whom we speak. With historians, we speak with historians, and historians have their frames of judging the way we speak. And as lawyers, we speak mostly to lawyers, and lawyers have their standards of excellence and thresholds of professionalism. How much those standards of excellence and criteria of professionalism differ has, I suppose, to do much of how we then, in our professional and academic lives, differ in what we say. We have chosen, Annabelle and I, 6 topics in which we have paired a historian and a lawyer to think about these matters. Somebody said, Karen Knopp said a moment ago, that it looks like a Davis Cup. So there are successive pairs, who wins, who serves, at what point, how do you count the points? Of course, there are 2 audiences that count the points differently, and we can then, in the drinks afterward, compare the record that we lay out. I hope there will be some of the atmosphere of a Davis Cup tournament, but not just that. As I said, I'm delighted, also surprised to stand here that all of this organization has been laid out. I'm embarrassed to stand here as a co-organizer, as it says in the program, because actually, where was I? In Helsinki. And I come here and the table has been laid out. And I'm invited to act as one of the hosts, so I really have to thank Annabelle, Megan Donaldson, and their team for having done this wonderful job in organizing this. So, I welcome everyone here, and I invite the first panel to start. And I'm surprisingly chairing that first panel. So if Anne and Richard, we can take the table. Okay, so the first panel now is on method, the first tournament. And we have decided that Richard will start and Anne will take on from there. So Richard will serve, and he will serve standing up from the podium.
Well, thank you, Marty. Thank you, Annabelle. I'd like to add the thanks of the guests to the thanks that the hosts have extended to everyone who's organised this conference. I'm very excited to be part of it and looking forward to the final result of the tournament. It looked to me a little bit more like Wimbledon than the Davis Cup, actually. So, method. We're in Cambridge, and we've been asked to talk about method in the context of the relationship between political thought and international law. So I suppose I'm obliged to begin with the usual disclaimer. I doubt if there are any two people who have studied the history of political thought in Cambridge in the past 60 years who fully agree with one another on methodological principles. If there is a Cambridge school, it's very hard indeed to define. I would say that the distinctiveness of what was produced here over at least the first part of that 60-year period arose from the simple fact that, more or less uniquely in the world, Cambridge decided in the 1870s expressly to teach political science under the guise of history. That was the justification for the foundation of the historical tripos, the history department, that it was a way of teaching political science. In what other history departments could one study as a matter of course, not merely the history of political thought, but also theories of the modern state, which had become, by my time as an undergraduate, a combination of the history of 19th and early 20th century political thought and modern political philosophy, but which, when it was founded in the late 19th century, was straightforwardly contemporary, late 19th century political theory. And that remains an element in the tripos to this day. So the study of political thought at Cambridge always involved a combination of its history and, to a degree, an ahistorical or philosophical approach, and its practitioners shuttled backwards and forwards between the two and tried in various ways to align them. The same, appropriately enough for our purposes, and very strikingly, could have been said about international law, which was also taught as a freestanding area of political science within the history faculty, from the foundation of the tripos in 1873 down to as late as 1951. Before my time, but in living memory, you could do a course on international law under that name in the history faculty. I suppose it lives on if it lives on at all, in the extensive interest in Cambridge in global history. But it's an illustration of the peculiarity of the history of these subjects here, and the fact that this conference, oddly enough, reunites under the aegis, as Annabelle has said, of the history faculty, precisely the two subjects which used to be at its heart. And that's worth pondering, I think. Now, my own view about what this interest in the historical setting of political theory has delivered, and by historical setting, I mean not simply the actual political circumstances in which the theorists lived, though that's often taken to be the meaning of context, but the general character of their society, the intellectual inheritance of their age, and even their own personal life history. That is, anything which might conceivably be relevant to the writing of a work. My own view is that what this interest has delivered is twofold. One aspect is sometimes overlooked, and I'll just talk about it very briefly, but it's important to the actual practice of writing intellectual or cultural history. Putting a writer into his or her setting not only changes our sense of the writer, it can also change our sense of the setting. It's easy when writing cultural history or intellectual history to teach the ideas or beliefs one is studying as if they have floated free of their actual bearers and become hypostasized. And it's equally easy to reify a context until it no longer seems to consist of the activity of actual people. But when we study the major theorists in their setting, and we know a great deal about those named individuals, we will inevitably give full weight to the complexity and concreteness of the ideas of an individual thinker, and usually of a very serious and interesting one. Seeing in detail how the ideas are anchored in the life of a specific named individual, and being able to do so at some length, is a valuable corrective to the tendency of intellectual history to become a history of ideas, as if they, the ideas, are the historical agents. Obviously, this is possible in other areas in political theory, but the political theorists that we study have the distinction of actually thinking explicitly about their societies, and a full historical knowledge of them and their works can tell us much of what we might want to know about the social and political character of their time. So that's what I think this has done for intellectual history, if that term means very much. For the students of political theory, among whom I count myself really rather than as an intellectual historian, for the students of political theory, to turn to the other aspect, an historical approach, I think, has had the surprising result that it has usually rendered the texts we study more, not less, relevant to our current concerns. This is because, or partly because, the more we get a vivid sense of what actually mattered to the theorist, the more we tend to find that something like that can also matter to us, and that the theorist's response turns out to be a new and often disconcerting way of thinking about the subject. To put it another way, what was wrong with the old idea that there's a set of universal questions with which the great theorists have grappled, and which indeed the set of questions defined the canon of great theorists, so-called great theorists, as the ones who dealt with those questions, which was one of the chief targets of John Donne and Quentin Skinner in their early work in the 60s, this picture of universal questions. What I think was wrong with that idea was that the scope of the set, as it was studied in the mid-20th century, was in practice very limited and rather simple-minded. And what happened as a consequence of people beginning to think about the historical setting of the ideas and the writers in a much more targeted way, much more detailed way, is that this bust apart this narrow and boring set of issues. But I don't think it turned the historians of political thought into antiquarians, the way that they're sometimes condemned, because the real issues of the past turned out to be of far more than antiquarian interest. This, incidentally, would be my answer to Marty's powerful argument recently against what he's described as the historicism of full-scale contextualism. Though one might not have expected this, so if one thought of it, one could see how it happened. One might not have expected it, but the contextualist turn, in practice, I think, produced anything but historicism. And the best example of this, I believe, is in fact the subject of this conference. Obviously, there have been histories of jus gentium, or international law, as we know it came to be called, since at least the late 18th century. Interestingly, one of the first, by Robert Plumer Ward, whom Jem Pitts in particular has directed us to read, expressly used an historical analysis of the jus gentium as a means of dissolving the idea of a universal law and restricting it to regional groups of nations. As Ward said, what is commonly called the law of nations falls very far short of universality, and therefore the law is not the law of all nations, but only of particular classes of them. He's writing at the end of the 18th century. The law is not the law of all nations, but only of particular classes of them. Not only this, but even there may have been very different sorts of law of nations, according as revolutions have taken place in the religion, system of morality, and local institutions of the nations which compose it. All this, Ward said, all this was to be proved from history, if proved at all. The book was published in the same year as Kant's Perpetual Peace, and is, I think, rather curiously similar to Kant in its restriction of the term law of nations to the internal agreements of regional groupings of states. I mean, there's obviously no contact between the two of them. It just looks like the zeitgeist in some sense. But I think it's a very striking example of the early use of history, a history of international law, as a way of subverting claims to its universality. But that's not the only way in which the history of international law could go. Other historical studies try to go in the opposite direction, and show that beneath the various accounts of the law of nations, at least in, though they didn't acknowledge this, the European tradition, was in fact something much closer to a common and universal human morality. I think this was the underlying purpose of the Carnegie Endowment editions that in fact we all use all the time. I think those of us who work on the history of this stuff. But these histories of international law, under that name, or histories of the law of nations, were all rather detached from the general history of political theory, which people were writing from the late 17th century onwards. And they displayed many of the rather depressing characteristics of all histories of specialist disciplines, like the history of economics as practiced by economists. And when historians of political thought, whom, as I said, had been trying to write the history of their discipline, or at least what Jean Barbarac called the history of the science of morality, but including politics in a major way, when they turned to the major figures who had dealt with international law, most obviously Grotius and Pufendorf, they almost always treated them largely as theorists of natural law. I mean, that was their slot. And the historians were not, in those days, the historians were not especially gripped by the fact that their theorists were spending so much effort on thinking about international relations. And they certainly didn't think that the exigencies of international politics were at the heart of many familiar works of political theory. Now, to be autobiographical for a little bit, I was first aware of a change in this respect coming over the writing of the history of political thought during the 1980s and early 1990s. I mean, Marty has referred to the growth in, if you like, a historicized interest in in international law, and correspondingly, as I'm saying in my talk, the internationalizing of the history of political thought. It's certainly growing at the moment, but I think you can trace, at least in certain aspects, its origins to that period. Since I was in Cambridge at the time, it was what was happening here which first struck me. But I suspect a similar story could be told of developments in other places. Cambridge just happens to be a very concentrated site of activity in our discipline. Now, one of the first examples of taking the international context entirely seriously as a way of understanding a major text, we shouldn't forget, was the late Istvan Hont's Rich Country, Poor Country article of 1983, which grew out of the Wealth and Virtue project at King's, and that he and Michael Ignatieff ran, and which was intensely focused on the question of the international setting, the global setting, for 18th century writing on economics. The article proposed, Istvan's whole view was, that the 18th century was deeply concerned with the comparative economic development of competitive nations, and that the theme of global competition was at the center of a very wide range of writings, including most obviously, but it had tended to be forgotten, the wealth of nations, nations plural. As you know, I mean, on the whole, the Wealth of Nations was read by, again, the historians of economics as if it was an account of the wealth of a nation. But that is not what it's really about. Istvan's well-known later article on the permanent crisis of a divided mankind in 1994 made his position on this extremely clear, as did all his work down to his untimely death 3 years ago. But between 1983 and 1994, other people made a similar move, that's said between Rich Country, Poor Country and the permanent crisis. Jim Tully, for example, was one of the first people I know to take Locke at his word when Locke said, "In the beginning, all the world was America," and to ask questions about what precisely the American context meant for Locke in a paper he read to the Locke Conference at Oxford in 1990 and published 3 years later. I'd actually already in the previous summer, unknown to him, since for many years we've seen each other much less often than we used to, written a paper outlining the argument between Grotius and Pufendorf about colonization with a brief excursus on Locke. When we exchanged the papers in September 1990, we found that we'd independently come to the same conclusion, that the issues of America and international affairs were far closer to the center of Locke's two treatises of government than earlier scholars had ever been prepared to say. So it's an example, I think, of the zeitgeist. I mean, that we'd independently become interested in internationalizing Locke or seeing the issues of colonization, settlement of America, and so on, as absolutely at the heart of certainly chapter 5, and I think much more of the second treatise. I'd also been trying for some years to take Grotius's early work on De Jure Praedie as his foundational work, where all his most interesting ideas are developed. first, in order to show more clearly how his natural law theory was intertwined with the practical needs of Dutch imperialism. Jim followed up his interest in the global dimension of political theory with his Seeley lectures on strange multiplicity, while I explored the issues in my Carlyle lectures in 1991 on the rights of war and peace. Now, this turn to the international dimension of these classic texts had many consequences. But I want to single out one in particular to illustrate my point that we ended up with something far removed from antiquarianism or historicism. What these ways of reading Grotius or Locke, or it turned out from the works of Jen, Sankamutu, Karuna Mantena, and many others, reading a whole array of familiar Western theorists, what this told us was something deep about the ambiguity and complexity of modern liberalism, whether articulated in the form of rights theories or in the form of utility theory, for Bentham, Mill. Equality and freedom turned out often to mean their opposite when applied in certain quite specific colonial contexts. Thus, it turned out, on the view of many of the people in the 17th century, that it was the Native Americans who supposedly threatened the lives of Europeans by their insistence on using vast tracts of the continent, supposedly as hunting grounds, at a time when Europe needed all the food it could lay its hands on. And that's not completely crazy. I mean, it's strange, but it's not completely crazy. Or, something I pursued in a recent article, it was the reluctant acceptance, very reluctant, acceptance by early modern Europeans, particularly Protestants, that they could enter into full-scale treaty relations with so-called infidel nations. There was a very long tradition in Western Europe, drawing really from the Bible, many biblical texts, that this was illegitimate, that the Christians could not enter into treaty relations with non-Christians. It was the reluctant acceptance eventually, I think sort of pioneered largely by Grotius, actually, one of his major changes in international law, that you can have treaty relations with infidels and treat them as equal partners in global arrangements. You can treat them as participants in the making of treaties, which, again, very paradoxically, facilitated the development of the fundamental structures of imperialism. Because the fundamental structures of imperialism, as we know, are not the result mostly of brazen acts of conquest, that's very rare, but of intervention in other people's wars, which they still are. I mean, that is still the basis of the modern version of imperialism. And you intervene in other people's wars when you treat them, at least ostensibly, as equals. You can form military alliances. I mean, it's the military side of these treaties which is critical. People always thought you could trade with infidels, but a military alliance with infidels was shocking, deeply condemned, and yet it was absolutely necessary that military alliances be made with infidel nations for Europeans to develop their empires. That's true even in North America. It's obviously true in Asia, but it's even true in North America, where they could have done very little without military alliances with Native American peoples. Now, these paradoxes and contradictions that came so vividly to the surface once we started to ask these questions about the actual historical setting of these familiar writers, these paradoxes and contradictions are not mere mistakes. They're much deeper and more interesting than that. What they illustrate, I think, is actually a fundamental fact about political theorizing of any kind. And I want to conclude by saying something about this. Now, we're accustomed, naively, to think that the foundational principles of a theory are what really matter, and that a set of relatively determinate conclusions can be drawn from them. If the conclusions which the theorist actually drew from them are, to modernize, out of line in some way with the fundamentals, that's dismissed as an aberration. A particularly good example of this would be Kant. I come from Harvard. Despite the fact that repeatedly Kant does not say about politics the things his modern admirers think he should have said, for example, his account of the state is barely distinguishable from Hobbes's, and his cosmopolitanism was of an extremely exiguous kind and expressly hostile to global political structures. Bookshops are full of works trying to produce Kantian accounts of ethics and politics. I am tempted to say, as Kant himself said, about the books of his own day purporting to prove the existence of God or free will, that I'm very keen that there should be such works, even though I know before I open them that they must be wrong. But neither Kant's own superstructure nor the modern superstructures, in fact, follow from his premises. The relationship between base and superstructure, to use that terminology, is much looser and indeed more puzzling than that. There are a vast number of moving parts in any theory, and they can be adjusted in such a way that almost anything can be presented as a conclusion. Rights theories can easily be used to support absolutism and the destruction of civil liberties. Hobbes, on one reading of Hobbes, maybe not the correct reading, I don't know. And principles of freedom and equality, as I said, can easily be used to support colonialism or even forms of genocide when we think about what happened to the Native Americans once they were treated as equals, possibly. And yet, and this is the central problem of our trade, I increasingly think, the relationship between base and superstructure, between foundation and conclusions, is not an arbitrary one. It's not random. So how do we put our finger on the character of the relationship? And I've been trying to think about this recently, on and off, and the best description I can come up with so far is it's a kind of, much misused term, a kind of elective affinity. Our sense of Kantianism or Hobbesianism or Marxism is conditioned by our awareness of the way the theorists themselves juxtaposed and moved backwards and forwards between their foundational principles and their more practical conclusions. And it's not a straightforward relationship. It's a kind of dialectical relationship, though without the precision of the dialectic in Marx or Hegel. And it's of critical importance, I think, that the different parts of the theory are, so to speak, held together in an actual human mind. They're more like dispositions than propositions. It would misrepresent them to present them as, so to speak, an abstract set of things that has been generated in some fashion by, let's say, a computer. It's of critical importance that it was a human being who put these bits together. And they display the kind of integration which the different parts of a personality possess, rather than the integration which we can see in a set of logically interrelated propositions. Both the base and the superstructure together form a way of looking at the world or thinking about it. Now, I don't think we could have grasped this fact about political theorizing if there hadn't been a turn to a historical approach to the subject, since built into the older alternative was an almost exclusive concentration on the foundations. This, for example, was why, as I said, Grotius and Pufendorf were treated in the older histories as theorists of natural law, and it's why in philosophy departments to this day, people write about the theorists in what looks to us, the sort of historians of political theory, as a very curious and old-fashioned way of writing about theory. Because it's they also suppose, many of them, not all, obviously, that get the foundations right and you can generate the new version, the correct version of Kant, as I said. The historical approach, I think, freed us to see complexity and paradox everywhere we looked, and to understand the subtle ways in which theories can apparently undermine themselves. At that point, interestingly, and perhaps we can talk more about this later, there was to a degree a convergence between the largely Anglo-American story, indeed largely Anglo-Hungarian story, I guess, well, no, Anglo-Hungarian-Canadian story I've been telling, and Foucault, obviously. Though I think from our perspective at the time, there was a much greater hypostasization, as I've termed it, in Foucault than we were keen on. Ideas are almost the agents. And in this sense, I think Foucault remained a surprisingly old-fashioned historian of ideas, though that there is much more to be said about that. The modern understanding of international law, so well represented at this conference, is a prime example of this process, of seeing the complexity and paradoxes. Has international law freed the inhabitants of the world by putting them under a legal order? Or has it dominated them through the use of categories which subvert their existing lives and present them with agentless and uncontrollable sites of power? I don't think we would have been so aware of these questions, of the utmost importance for our own time, had we not taken the historical turn in our subject.
Well, I'd like to join in thanking Annabelle and Marty for the invitation to be here. And as Marty just announced in opening, they confirmed at dinner last night that each session stages an encounter between an intellectual historian and an international lawyer. And as you also all probably know, Annabelle and Marty can both be very inscrutable, so it wasn't clear how they envisaged these encounters as adversarial, dialectical, or a performance of a common project in which we hold hands and move forward in a unified endeavour. But I must admit, I woke up at 2:30 with the disconcerting feeling that I was the first speaker for the negative in a school debate where I wasn't quite sure what the topic was. So if I look a little bleary-eyed, that really never quite left me. So I'm going to pick up where Richard left off and ask, what has the historical turn meant for international law? So international lawyers are now becoming very familiar with the claim that our discipline has taken a historical turn, or to borrow the language of a number of my more dramatically inclined international law colleagues, that there's a battle for the soul of international law being played out on the field of history. So in one sense, there's nothing new or particularly radical about international lawyers engaging with the past. Past texts and concepts are constantly retrieved and taken up as a resource in international legal argumentation and scholarship. Indeed, we might include international law amongst what Lorraine Daston has referred to as the sciences of the archives. These are human sciences that not only create disciplinary genealogies and accumulate disciplinary law and anecdotes, but also depend upon collecting and classifying data to pursue disciplinary argumentation and research in the present, and to ensure the possibility of research into the future. So botanists collect type specimens, geologists collect core samples, demographers consult parish records, and art historians study museum and gallery collections. So international lawyers also constitute, curate, classify, and depend upon historical materials. Our archives include collections of judicial and arbitral decisions, treaty collections and their drafting histories, records of state practice, the decisions and resolutions of international organisations, the reports of fact-finding inquiries, witness testimonies, expert evidence, and in the words of the Statute of the International Court of Justice, the teachings of the most highly qualified publicists of the various nations. So the reference to a turn to history obviously then doesn't mean there's not been an engagement with the past before recent decades, but rather I think it refers to two novel developments in the engagement with the past of international law. So the first is that since the 1990s, we've seen the emergence of a body of scholarly writing by international lawyers interested in unsettling celebratory histories of international law as a profession self-evidently working collectively in the interests of a common humanity and universal values. So here the idea of a turn to history is not so much an engagement with the past of international law, but in the critical ambition and potential of that engagement. So that work has taken many forms. Many of its authors are in the room. Let me just mention two ways in which international lawyers have gone about that. One has been to study the past and trace the legacies of imperial formations in contemporary legal concepts, practices, and institutions. So this is not work that's seeking to make an argument about responsibility for past injustices necessarily, but rather seeking to analyse how imperialism is embedded in the structures, techniques, practices, and concepts of a supposedly decolonised international law in the present. And scholars associated with the Third World approaches to international law, or TWAIL movement, particularly Anthony Anghie, were important players in this ongoing debate about the relevance of the history of imperialism to modern international law. A second critical approach sought to counter the more monumental disciplinary histories of international law by providing a more complex and nuanced history of the profession. And here, Marty's History of the International Legal profession, the gentle civiliser of nations, is quite properly seen as a milestone, and it's shared with other scholarly writing at that time, a lot of it organised around Harvard Law School, an interest in the history of the self-understanding and sensibility of international lawyers and the relation of the profession to a broader range of political, social and cultural developments in the late 19th and early 20th centuries. So that work offered a powerful counter to the idea that international law exists as a coherent system of objective rules that determine outcomes, arguing instead that what international lawyers championed as either scientifically deduced rules in the positivist version or progressive developments in the realisation of a universal history in the natural law version were after all just human constructions, the product of struggles between people with political projects seeking to establish their domination of a vision for the world, trying to assert power over others, and affecting the distribution of material and spiritual resources. So the second phenomenon, characterised under the heading of the turn to history, is then an expansion of scholarship outside the field of international law, concerned equally with this question of how the past is relevant to the internationalist present. And here the desire to understand how and why international law and institutions have come to be such a powerful influence on international and domestic politics has fueled new fields of study and new interdisciplinary encounters. So the study of the past as it relates to international law is now a project being undertaken not only by international lawyers and legal historians, but also by scholars in world history, global history, imperial history, the history of human rights, the many variants of intellectual history, as well as philosophy, politics, literature, post-colonial studies, and critical geography. I could go on. So the result from the perspective of someone trained and disciplined as an international lawyer is intriguing and enriching, also, as Marty said, sometimes puzzling and surprising. And the size of this audience suggests I'm not alone in having this response. So the turn to the past within and without the discipline of international law has led to rich and evocative new studies of the international law profession and of major figures invoked as part of its tradition, opened up new conversations about the overlapping histories of international law, international relations and economics, and paved the way for critical accounts of many subfields, again, authors in this room, including of international human rights law, international trade law, international investment law, and law on the use of force. But at the same time, the interdisciplinary encounter has raised many methodological questions about what it means to engage with this object that we call international law, or indeed what this object is. So sociologists announce that international lawyers should be engaging with the work of international law and institutions by using sociological methods. Anthropologists and ethnologists tell us the proper way to think about the everyday life of international law, and lawyers is to take up anthropological and ethnographic methods, and historians explain patiently that we should adopt historical protocols when we engage with past concepts and texts. And my interest has been in the tensions this produces between the two versions of the turn to history phenomena that I've just described. That is, between work that seeks to engage critically with the practice of international law and work that understands itself as engaged in some way in a professional historical project. So I'm going to very briefly sketch some of the methodological tensions to which this encounter has given rise, and then explain why I think they matter for critical work in and around international law. So, the disciplinary approach adopted by historians like Marty, or disciplinary historians of the field, has received a much warmer welcome from intellectual historians than did the third world approach I just described. And in particular, this work that I've suggested we could call the Twale School has been met with charges that would be familiar from the Cambridge School, though I take Richard's point, there never is a school. And I think the flavour of this can be taken away from the response of the Australian intellectual historian Ian Hunter, who's, I think, systematically taking on many critical international lawyers one at a time. Marty's the latest, I think, and who's argued that the critical work of international lawyers is dogged by debilitating anachronism and presentism. So this policing of anachronism has been a major theme in the response to critical histories of international law amongst such scholars. So they've sternly cautioned international lawyers for making fanciful connections between scholars of different periods, for taking daring jumps that destroy the pluralism of different periods, and engaging in forms of historical revisionism, these are all quotes, that abandon the standards of historiographic analysis. Other work has addressed the turn to history by pointing to the deplorable results of genealogic history from past to present that leads to anachronistic interpretations of historical phenomena, clouds historical realities, and gives no information about the historical context. I'm there quoting Randall Lassafa, who in many ways otherwise agrees with what I'm about to say, but was having one of those moments of his historiographic propriety. So the combined effects of the move by historians and legal historians to dismiss critical thinking about international law and empire became evident to me when I attended a seminar at which a distinguished and influential professor of international law repeatedly counselled early career scholars against trying to track the relation between legal concepts, doctrines, or institutions developed in the past and contemporary legal debates. And this, according to the professor, involved taking an ahistorical twale approach, which it was wiser to avoid in favour of proper historical method. Yet, as I said in response, the twale approach could equally be called a legal approach. Twale scholars, like legal scholars, engage in the practice of developing arguments about contemporary political problems that draw on inherited concepts with a history of legal meaning attached to them. So let me say then why I think this matters for how we think about international law. As I've argued in some detail elsewhere, applying methods from intellectual history threatens the very goal of understanding how meaning is made in international law. To mandate historical methods as the only means for engaging with past texts makes it impossible to understand how meaning is made, transmitted, and transformed in international law, and to grasp the function of legal concepts adequately. So before I say anything further, I want to make clear that I'm not questioning the notion that we should understand text in context. I think this is something shared between international lawyers and intellectual historians. But the polemical argument for contextualism in the work of intellectual historians is tightly bound up with an idea about time that marks the point at which critical international law, and indeed international law, parts company with this approach, in my view. So Peter Gordon has called this contextualism as containment. And we can get a sense of this here if we think about the stress that's put on the notion of anachronism. Anachronism refers to something that's not in its correct time. And a lot of work goes on in determining what is the correct time in which a concept or idea should be placed if we're to grasp its meaning. In his early manifestos, Skinner argued that scholars should concern themselves with studying what an author meant in the temporal context of the given occasion when an utterance was performed. And in an attack on the great chain of being style of reasoning that had shaped much American intellectual history, he also argued that it was a mistake to study past texts in order to trace the morphology of a given concept over time. Of course, there are many intellectual historians who contest this strong separation of past and present championed in those early manifestos, and more particularly the idea that we can't trace concepts over time. But as you can see, these arguments are still being used to challenge critical work in international law. So let me suggest a number of reasons why that's a problem for understanding. First, the argument that international lawyers must work according to historical protocols ignores the way that international law operates. It's not plausible to instruct a lawyer to think about a concept purely in the past or indeed in the present tense. Lawyers work by invoking a history of meaning that's accrued to legal concepts, principles, and doctrines over time. Indeed, one goal of legal education is to teach new lawyers how to assimilate the complex set of political debates and logical moves that are condensed into particular legal concepts or fictions, such as aggression, or protection from expropriation, or freedom from torture, or collective self-defence, or military necessity. The list could go on and on. So the end result is that over time those concepts are worn smooth. We don't have a debate every class about whether that's really what the reasonable man would have to do in this situation. And the end result is that, at least for lawyers who've grown accustomed to them, these concepts cease to be politically volatile. So legal fictions and legal concepts are highly condensed forms of rhetorical material that allow often highly controversial political and philosophical propositions to be passed on as part of legal routine. Critical work tries to recover that process and reanimate the political potential embedded in legal fictions. So the attack on anachronism will not shut down the movement of law, but it will shut down the capacity of critical thinkers to engage with it. Second, and as a result, legal concepts or texts are not simply the product of a single act of creation by a powerful agent at a particular moment, but are also produced through the process of handing on from one legal act to the next. Annalise Riles has invoked this mode of legal production through transmission in her discussion of the afterlife of legal judgments, exploring the way that legal fictions are sustained through being passed from legal hand to legal hand, analysed by scholars in journal articles, invoked in arguments before courts and tribunals, cited by later judges, and taught in classrooms. So through those often arcane rituals of legal life, involving transmission and testing of such interpretations, lawyers give to legal texts a heightened sense of reality and purpose. So while we might want to study the moment in which a text is written, a statement is uttered, or the drafting of a court judgment or a piece of legislation, what's more emblematic of legal knowledge production is the practice of repetition through which legal concepts, principles and fictions come to seem, indeed come to be, real. In studying international law, it's therefore essential to grasp not only how concepts, principles and institutions that shape the field emerge, but how legal techniques continue to give them authority and meaning. Third, international lawyers also do this work of invoking past texts as precedents and drawing on the histories of meaning embedded in legal work, while operating within a field and an institutional culture that is characterised by its adversarial nature. So appealing to past concepts, either to show why those concepts relate to the present or should be distinguished as irrelevant, is central to the legal process of adversarial interpretation in which something is always at stake in the present. And finally, international law is also a field of practice that is the site of an enormous investment of time and energy by politicians and public officials who are in turn intent on ensuring that this symbolic economy remains within their control, who know that lawfare or verbal strategy plays a central role in international politics, for whom concepts and principles matter for multiple reasons. So controversies over and changes to things like the Trans-Pacific Partnership or the crime of aggression are hard fought, and so are the legal concepts embedded in them. So all of this means that we can't simply apply interpretive protocols borrowed from history to determine the meaning of legal concepts, or indeed to understand the meanings attributed to the work of a particular scholar. To take one example, the idea that the only proper context for studying the effect of Vittoria on international law is the world of Salamanca in the 16th century ignores the multiple contexts for the discipline of international law of writers such as Vittoria. So attention to the context in which he was reclaimed for modern, brackets American, international law shows that early modern jus gentium was systematically and carefully reconstructed in the US at the dawn of the 20th century to make sense of practices and institutions that were already reshaping the world. Vittoria's humanitarian critique of Spanish Empire was invoked by what Skinner would call ideological innovators, such as James Brown Scott, to provide a language for rationalising the form of empire that would triumph in the 20th century. So, of course, Richard Tuck was right to say that the first generation of scholars who looked systematically at the early modern jurisprudence of war, that is, the scholars funded by Carnegie, left us with a very misleading picture of pre-Groscian ideas about laws of war and peace. And as he comments, like many older historians of a particular discipline, they assumed that the subject of international law was gradually uncovered and understood in increasing less primitive terms. And yet those modern international lawyers did successfully weave Vittoria into a universal history with the cosmopolitan purpose that has reshaped our world. So as inheritors of both Vittoria and Scott, international lawyers can't ignore these shifting contexts. So to conclude, I don't want to end on too despondent a note for this encounter between intellectual historians and international lawyers. Such interdisciplinary tensions are, of course, a commonplace of interdisciplinary work. And this is well captured by Warren Breckman, who's noted that the differences between disciplinary methods, problems, and goals are often such that there's a moment in interdisciplinary work when we realise that the ostensibly shared object is now barely recognisable. As Beckman comments, my Hegel is not your Hegel is an unspoken thought that may well occur to both the intellectual historian and the philosopher halfway through a chat. So how to respond to that? One possibility would be to say, okay, it's all over, let's put up the barricades, this is impossible, but that wouldn't be desirable and it probably wouldn't also be very fun. A second possibility would be to argue for a more relativistic approach. And I did for a time think this was the appropriate pluralistic tone on which to finish. You have your methods, we have our methods, we could just hang out and that'd be fine. But I decided against that. So I want to suggest that we should reconsider what the historicising of international law as a critical gesture might mean for the field going forward, both institutionally and methodologically. I think institutionally we should reject the idea that it's important to have a more professional form of history writing and a clearer delimitation in the relations between the practice and the history of international law. I think that would mean that the vital sense of the inherent interrelationship between history, theory and practice of the discipline would be lost. And I also want to suggest that contextualism as containment is not only a bad thing for international law, but also for political thought more generally. And indeed, recent work in global history by David Armitage arguing for a return to the longue durée perspective, or Andrew Fitzmaurice arguing for serial contextualisation, is moving in that direction. But contextualism as containment ignores or rejects the sense that an idea or a concept carries with it a vitality that, in the words of Peter Gordon, it exceeds its original context of articulation and remains open for novel modes of critical appropriation. Perhaps what needs to be debated is not whether we should make daring jumps in our thought, but rather how and to what ends. Thanks.
Well, it's hard to imagine a better opening. I won't call this a match, although I think that there were balls flying in from one direction to the other at least. And now it's open for a discussion. I note also that we have 2 sessions for method, issues of method, this one and the one after coffee. So the debate will continue, but let's open it now. So we have the possibility to ask questions, elaborations, responses. Jen.
So I have a question for Anne about your note of pessimism at the end, because it seems to me that the picture that you presented is actually one of a huge amount of compatibility between a contextualist approach and what you're suggesting. It's just that, I mean, it's serial contextualism is maybe the best way to put it as you wound up, that you're saying we need to be attentive to the various contexts in which Vittoria, say, was taken up at later moments. What happens to his arguments and ideas as they're invoked and redeployed in various contexts? And to me, that's exactly what a contextual history is so ideally disposed to do. So I don't see the gap. And maybe, you mentioned Ian Hunter and Randall Lassafer as 2 of the critics of Enki, but Lassafer's a lawyer in any case. So that's not a battle between law and history, but maybe one set of disgruntled people from various places who don't like what Enki did with Vittoria. But my sense also of the reception of Enki's work in history of political thought, political theory, is that it's been wildly enthusiastic, and that Hunter's a bit of an outlier.
Okay, I'll take 3 questions from the floor that have been asked. Nathaniel and Walter. Nathaniel.
So thank you for the great talks. I wanted to put something on the table, a danger that I don't think either of the incredibly wonderful talks fell into, but I think that it's a thing to flag, which is in this kind of interdisciplinary encounter, the big danger, of course, is the reification of the disciplines. But it's actually, as Anne said, bound up in the structure of the Davis Cup thing. And so it is the big danger, and that it's sometimes even the most critical people can fall into the trap of taking the disciplines for granted. And it seems to me that some of the best work representative people in the room or in the front of the room, it also involves problematizing the historicizing, problematizing, questioning the existence of the disciplines and the extent to which the disciplines are constantly being re-disciplined or self-disciplined. They recreate themselves in each period in part through a variety of techniques, sometimes drawing in history, sometimes not drawing in history, and that's the real, for me, that's the real work, is not so much your method or my method, but how is it that at a particular moment the self-identity of the discipline could be constructed so that it might actually be detached from its history or whatever. So I just want to put that on the table. It's the historicizing, the problematizing of the disciplines, both history, and we can learn a lot from, say, Deepa Chakrabarty about provincializing the idea of history, right? And certainly law, which is anytime anyone purporting to be a law person speaks, they're recreating the idea of law or reinventing it out of whole cloth. So I just wanted to put that on the table. It's not really a challenge to the talks, but it's just sort of a caveat to the project of the days that we're in.
Take a third one, Walter.
Two remarks. One is about the view of contextualism, because in Richard's paper, if I understood properly, you present contextualism as a kind of advanced form of history writing compared with a less sophisticated, less advanced forms of writing. That might be problematic in terms of seeing ourselves as getting things right, whereas other historians didn't quite get it, or at least not in the same way. And then it might also be problematic in terms of the normative implications that contextualism has, because contextualism also is a terrain of travel. Some people use contextualism to look at the paradoxes of liberalism, like you said. That's your view, and I guess many of us agree on that perspective. And others, however, might use contextualism actually as a weapon precisely to demonstrate that, because we can't attribute any responsibility to historical actors. Perhaps there's no responsibility even then indirectly in the project of Western imperialism or something of the kind. And the second point would be about foundations, because the people who do the former, I mean, perhaps you and us and many of us, I mean, that look at context with the aim of looking at paradoxes in liberalism and so on, are they really free from foundationalism? Because what we are really looking at is, again, smoking guns. When we look at Hobbes, and we should look at how Hobbes actually starts with rights and ends up with absolutism, we do that to show that he got things wrong, that he didn't get equality and freedom as it should be. I mean, now I'm simplifying also for the sake of the discussion here, but the point is precisely, why are we interested in Hobbes' absolutism? We are interested in that because we are precisely against that project. Would we be interested in the same way had he developed his theory in a different way? Would we be interested to the same degree in his theory then? So are we really free from foundationalism?
Are you okay to start?
Sure, yes, no, thank you. Perhaps I'd also say, well, naturally, what I say is also going to respond a little bit to Anne's really fascinating and thought-provoking paper. Look, I mean, let me begin by saying, actually, I think I'm myself as a methodological anarchist. I mean, I think almost any method is legitimate. And it depends what you find interesting, it depends whether it produces interesting results and so on. What I wanted to talk about specifically in this context was one method, the method of, so to speak, historicising international law, and more interestingly, internationalising the history of political theory, one aspect of that, which arose out of thinking about the specific, I think historically this is true, that it arose out of thinking about specific contexts which turned out to deliver surprising aspects to the theory. I wouldn't say that it commits us to saying that we got it right, not at all. It may well be completely wrong. It's just that it does open the scope of the things that are going to be relevant for thinking about the central features of the theory. And that was what I was interested in. Of course, you can think about things in all sorts of other ways if you want to. There's no problem about that. But I think there is a danger or there's a risk attached to what I call hypostasization. In a sense, I want to keep coming back to that, because the quote from Peter Gordon, in fact, expresses the idea that ideas can themselves have some sort of life independent of people. And that seems to be a metaphysically odd view. So again, you can imagine, indeed we read some great theorists who did indeed take that view. But it's there, I think we have a big and interesting philosophical difference. But if you believe, as I do, that ideas are born by people and that thoughts take place in the human brain, then you are not going to want to think about the ideas as if they have this sort of independent life. And it seems to me that what we learnt from trying to historicize political theory and so on is very similar to what the critical legal theorists have been doing. That's the point really that Jen made, I think, absolutely correctly, because there's at least one aspect of what the critical legal theorists do, I think, at least, is to remind us that law operates in people, and that lawyers, judges, and so on exhibit just the same shuttling backwards and forwards between conclusions and premises that I've said that theorists do. I mean, lawyers are theorists, actually. I mean, that's all they are. And they exhibit exactly these features of theory that you can't straightforwardly disentangle the conclusion from the premise, and how people want the idea to come out in some way, subconsciously or consciously in the case of certain members of the Supreme Court, is obviously part of how they are thinking about the law. And it seems to me that the critical legal theorists, focusing at least partly on that, and the historicizing political theorists focusing on their bit of the world, came to rather similar conclusions. And that in both cases, the conclusion was that concepts are potentially politically very volatile. They don't lead a very straightforward and so to speak, independent existence. So, I mean, that would be my basic answer to many of the points that have been raised. And, I mean, in answer to Walter's thought about Hobbes and the question of responsibility for imperialism, well, two separate questions. I mean, first of all, the question of responsibility for imperialism, how far agency vanishes from this account, this sort of account. I would say, if anything, it's the opposite, actually, that it's interested in agency, it's treating the theorists, the writers, as agents. But of course, it also has to acknowledge the enormous number of agents of a much more sort of effective kind who are out there actually putting their foot on different continents and so on. But it treats the theorists as part of that story. They're all agents in different ways. So I think responsibility is still there, but it's very complicated, shared responsibility that diffuses off into all sorts of different ways. And then this interesting thought about whether we would still be interested in Hobbes if it wasn't that he comes up with absolutism. I'm a bit puzzled by that. I mean, it's not entirely a view I share, but there have been people who thought that was a description of Locke, for example, a sort of Hobbes who came up with ideas which weren't absolutist. but people seem interested in Locke. So you're getting something else, I think, if you're interested in Hobbes, which is, it's true, that one of the rather striking things about Hobbes, one thing that's always fascinated me about him, is precisely the twists and turns of the theory. It comes out in all sorts of surprising ways. For example, recently I've been arguing that he's actually a kind of radical Democrat and utopian. These things are not what one would expect. But so that's a feature of it. But if it were indeed the case that Hobbes is Locke, fine. I mean, that's a worthwhile text to read. So I'm a little puzzled by that. But
So Jennifer, so this is a conversation we've been having for a while, and so I was thinking about your invocation of serial contextualization, and maybe I would put the weight on the serial. So let's put it there. What work goes on in thinking about that series, and how do you understand the politics of that series, and how do you relate that series to the present? And it's that set of moves that I don't think is accounted for necessarily by this contextualist approach that looks for containment. I keep trying to understand what that thing's about. So I completely agree, Richard, with the idea that we don't want to think about ideas as if they have an independent life. Of course, that's absolutely right. I totally agree. I'm interested in looking at how ideas get embedded, how they get, what kind of networks ensure that they're transmitted, how exactly that takes place, how out of all the ideas in the world do we end up with these ones moving through time. That's all hugely interesting. But I am also interested in how we get these ideas moving through time, and that seems to be what. And when I raise that question as the question that I'm interested in, I keep getting an answer that tells me how important context is. So I'm absolutely in agreement on the context point. Sign me up. I agree. Great, I'm a contextualist. What I don't understand is this idea about containment and why we can't talk about that. And I think it's because it makes a break with the present. So to give you an example, and I've been worrying about whether to use this example because I think this book is really fantastic in many ways, but a scrap of paper. So this great book by Isabel Hull on World War I, it's been receiving rave reviews, including by Rosalind Higgins, former president of the International Court of Justice, in the American Journal of International Law last year. So the book is, scrupulously contextual, as rigorous a piece of archival research as you could have in those archives of the French, the UK and the German governments, not the Russian, and I think that matters, and maybe I'll come back to that. But so it's a story that presents itself as a piece of contextual history, and indeed that takes on the rest of us for being anachronistic, for not being responsible enough to look back at World War I properly and understand that it was in part about international law. Rosalind Higgins readers, and she says at the beginning, I want to be really clear, I'm not one of those people who thinks you should defend international law. I'm really worried about people who do that. I'm interested in particular issues. I'm a contextualist as well. But as a contextualist international lawyer, this is a really great history. It's so important, and it shows us how important the defense of small nations was at the beginning of the 20th century. What a central thing that played in international law. That is such a radical proposition politically at this moment in time. So what that reading produces, no one of either of those two people does anything wrong in contextualism. But you have to read that in the present tense of American politics. So we're being told this looks more like a just war, and no one's reading it properly as a just war moment. It was a just war for international law. This is at a moment when the US military manual is being rewritten as a just war manual, when we keep being told Obama gives his peace speech and says, I'm a just warrior. So yes, it's a perfect piece of contextualism, but it's absolutely connected to the present, and any pretense that it isn't is dangerous. So I guess that would be that. And Nathaniel, yes, I totally take your point on the reification of the discipline. I suppose I am, at this point, taking a step a bit away from disciplinary history as a strategy, because I think on some levels, I think it's exhausted its critical potential, at least for me. And Suzanne Martian wrote an interesting piece called Has the History of the Disciplines Had Its Day, that says, there's like the sociology of the professions, there's a kind of studied distance necessarily from the stuff, the material of the discipline. And at this point, I'm interested in that material and whether there's any potential in the world as it's configured for international law to be something that isn't unjust? And if so, you would have to be working with its materiality. So my interest is much more engaging with, in a kind of old-style Austrian socialist kind of way, with the conceptual material of international law.
Could I just come back to this question about sort of presentism, or the present, and the way in which a sort of contextualist approach is supposed to, in some way, block that off? I don't sort of recognise that, at least in the works that I find interesting. I mean, many of them, as a matter of fact, are sort of tracing a theme through from quite remote past down to something quite close to the present. I mean, that's just a matter of the practice of people within this world. But my whole point was thinking in this way about the complexities and subtleties and contradictions that we find as a result of using this particular heuristic is a way in which we also are going to think about our present situation. That's an absolutely key point that I keep making. This is why I was using the term antiquarian as a term of abuse that's often applied to, the so-called contextualists or the historical school or whatever, because it's that's the whole point. It's not at all antiquarian. What it does is offer a range of ways of thinking about the present that we might not have come up with had we simply been stuck with, as I said, the very dreary set of issues that were the staple of the history of political theory, and indeed political theory generally, in the mid-20th century. So I just think one should stress those two things, and I constantly try to emphasize that as a matter of practice, what turns out, by and large, in this way of thinking is not what you might have expected, because it doesn't turn out to be antiquarian, it doesn't turn out to foreclose, to say that there's only one way of reading these texts, and it's got to be the one which is, located in the past, and there is no applicability of that way to the present. That's clearly not true. It's not true of the practitioner.
So let's have a few more questions. So there's one, please.
I was very interested in the comment, Martin, that you made right at the beginning of this submission, where you made a distinction between historians and their interest in periods and lawyers and their interest in norms. And I wonder if that really gets to the heart of it, because you could also make a distinction about the purpose of those disciplines, that historians presumably are engaged in an open-ended investigation, an attempt to open a door to experiences that one can't have oneself, whereas the purpose of law is purpose-driven, and usually the purpose is to win a case, and so you choose your facts accordingly. And it brings me on to the question that I had for Anne, which is the content of this historical term. Because, as you indicated yourself, there is something intrinsically historical in all legal investigation. We go back and we cite old cases, and we not only go back and cite old cases in terms of interpreting the text, but we get into the intent of the drafters. And so, for better or worse, some of the debates in our time might be the American Constitution and the purpose of the original thinkers on it, or the reason for the word aggression in Article 10 of the League of Nations Covenant, or the placement of the semicolon in Crimes Against Humanity in the Nuremberg Charter. And so it seems to me like the idea of an historical turn within legal thinking is a bit of an old concept, a hollow concept, unless what you're saying is that the point of the term is a new form of academic purpose, which is to slaughter sacred cows.
Laurie.
So I'm a little puzzled because when I came in this morning, I thought I was a historian. So, but I'm not interested in policing antiquarianism. So I'm not, and I'm only interested in conversations about periods every once in a while. It's not really something I wake up thinking about. So I don't describe it as the object of analysis of what I do. So I tend to think about historians as being interested in processes of change. And so the part, Anne, where you were talking about the ways that meanings accrue and attach themselves to particular configurations and and settings and arguments struck me as really something that resonates very clearly with what a lot of us who call ourselves historians do. I wondered whether we weren't just getting sort of boxed in, or are you going to throw us all out? Because I don't think that we're all doing the things that you're describing. There seems to be just so much more possibility for cross-pollinization as lawyers look at processes of change and the way concepts develop over time, and as historians look at the way these meanings accrue and shift and attach themselves to different political and legal formations over time. I'm having trouble seeing this as a Davis Cup. It seems more like we're on the same side of the net. So I would just throw those things out there.
So there's a third one. Yes, please.
Hi. I had a question about what you were discussing at both speakers.
Could you speak up a little?
Sorry. So when thinking about law, one of the things that I find interesting as a legal historian is that there's a difference between an adjudicator and an advocate. And I think in a way to harmonize these comments by people like Professor Lefebvre and arguments that you made in your work as well, Professor Orford, have been this idea that the danger is in going to the past and going to the archives, for example, and trying to construct an argument like an advocate would. So therefore you miss perhaps certain elements of that historical context because you're trying to find an argument that helps you get from the past to the present. Whereas perhaps an adjudicator would be able to see the whole picture, and both of those are in law as well, and then come to sort of conclusions that perhaps was in the first speaker's comments, and Professor Turk's opinion. So is there a way to harmonize that, what Professor Lefebvre had said, where he said, go to the past, do your first phase of study is to look at everything, and then in the second phase of study, to be able to then make those contextual and also bring it into the present kind of arguments? Or are you saying that perhaps there is nothing wrong in going to the past and being a lawyer, being an advocate, and seeing what you need to make an argument? Or is there a distinction there?
So these questions are all more or less in the same direction. Is there anybody else who would want to ask a question or contribute to this? Thank you. Yes.
My question would also point to
Speak up again.
My question would also point to how sources of historians and sources of lawyers could be used in legal practice and legal investigation. You pointed to sources used to Article 38 of the ICJ statute and pointed to witness reports, preparatory work, but especially also to writings of the most qualified legal scholars. And my question would be: can we always distinguish between legal writings and historical writings, and to what extent can international courts take into consideration historical writings? Are they subjective, or might they even be used for truth finding? Or to what extent can historical writings be used by international courts for questions of truth finding?
Thank you. Before I let the panelists respond, let me just say something to this issue about the discipline itself. So when one deals with lawyers and law as a discipline, one very rapidly gets to conversations, very foundational conversations about what we are, and the boundaries towards other fields are really broken up. And a standard problem lies in, if you go to the academy, and you will find that some of us think of law in the academy as learning a craft. And then you think about advocacy and going to a law firm to work later on. Others think about the law as reflecting about a craft. And those people often are more interested in history or legal sociology, etc. And very rapidly in the legal field, these two groups of lawyers tend to diversify in their view of what the law really is. So especially if one encounters, or if a historian encounters a lawyer, one would have to be very sensitive first to finding out whether this is a craft person or a reflection person. But let me just turn. Can you perhaps first?
Am I speaking as a craft? Or? how to answer those questions. So maybe let me say it like this. I don't think there is something called international law that's waiting out there for us to find it. But I also don't think there's something called international law that's written down that we have to look at in the world and see if it matches the thing we have here. I think every time we tell a story about international law, we're remaking what that thing is. And I think that is a highly motivated act in a present where international law is a super powerful way of doing stuff. So there's just no way of telling a history of international law that isn't implicated in that project. So if you understand yourself to be telling a story about a history of international law, then you are implicated in a project that works in the ways I was trying to set out. That's how it works. Everything you say will be part of an adversarial situation. Even the intertemporal rule, which is supposed to be the rule that tells us how we think about juridical facts in the past. But you can never see it invoked without someone fighting someone else about what exactly that means and what exactly Max Huber, the arbitrator, meant. Was he really just trying to talk about this specific question of how you decide who has title to a territory, or was it really a principle that covered everything? And then if so, how do we read the second thing? And so what exactly context was he in? And actually, why should we read this guy anyway? So, it goes on and on like that because it's adversarial. That's what it's going to be like. So if you come into that kind of sport, that's how it'll be played. And so I suppose I'm trying to say I don't think there's any right way or wrong way to do that. But I suppose there's ways that are more or less in tune with how the field understands itself to be making meaning. And if your commitment as intellectual historians is to understand how meaning's made, then I think you need to think about how meaning's made for the people who are still practicing in that field. So, and I suppose that would take me to the point, Richard, that you made earlier on about, I think you had a throwaway line in your talk about the way economists do history as economists. And István Hont and Keith Tribe and all these other great people who I read all the time do this other kind of economic history, and then there's this dodgy kind, Philip Morawski, and wow. So, but then there's the dodgy people who are actually practicing economists. So that is a tragedy. That's a disaster for economics. So exactly that disaster is what I'm trying to suggest would not be useful for international law. It's not helpful to have a professionalised cadre of people who call themselves historians of international law who have no conversation with actual practicing international lawyers the way we see in economics, because I don't think that's been jolly. So I guess that would be that.
So I should begin by saying I think lawyers are political theorists with power, or at least with more power than most of us political theorists, alas, present. And that's the key point. As you'll have noticed, I talk all the time, including in my initial remarks, about political theory rather than history. And I said something rather briefly about intellectual history. But I think of myself as a political theorist, and I think that the relevance here is, what we're talking about, is that there was a certain historical turn within political theory which resembles the historical turn within international law, because international law is political theory. So you would expect to find the same sort of historical turn. And they're both areas exhibit exactly the same properties I was drawing attention to, which is this, what I call a sort of shuttling backwards and forwards between the conclusions, the practical conclusions, in both cases to some extent, and the theoretical foundations, and the complexity of that relationship. Such that in the end, what one wants to do is try and capture what the character of the use of past ideas, present commitments, and so on is in the minds, the brains, if we're going to be absolutely straightforward, in the brains of the legal practitioners. That seems to me, in a sense, all that needs to be said. That, of course, there's going to be a historical dimension, should be a historical dimension to the practice of international law, just as there should be a historical dimension to the practice of political theory. You can't do it all out of your head. And in a sense, I think a lot of what people in my sort of trade have been doing is thoroughly pulling back from the rather incautious remarks that Quentin made back in the 60s, about trying to have a sort of separation between the history and modern political theory. This extremely incautious remark he made that we should, when it comes to theory, we should do it ourselves, right? Well, I think those of us younger than Quentin came to the conclusion we can't do it ourselves, actually, nor should we. that there is inevitably going to have to be some sort of relationship between confronting and reading the familiar texts and thinking about the present day, both in political theory and in law, and indeed the practice of modern political philosophers and modern lawyers just bears that out. It's virtually impossible. It's turned out to be virtually impossible to fully detach yourself from dealing with these works and to talk as if you are genuinely doing it yourself. Even Rawls, who I suppose Quentin partly had in mind in the late 60s, patently did not do that. And I don't know anyone who has.
Okay, thank you very much. So there's a lot of stuff on the table. We will have a coffee break now and continue with the second panel in half an hour.